Some breaking news. The Supreme Court has released its decision in Murphy v. Missouri, also known as Missouri v. Biden. That's the social media jawboning case about whether the federal government violated the First Amendment when it encouraged social media sites to take down speech that was contrarian on COVID and some other subjects. So this was an important free speech case, and the Supreme Court has ruled 6-3 that the plaintiffs did not have standing to bring this case. In other words, this is a win for the federal government. The Supreme Court has allowed the federal government to continue to engage in the very behavior it did over the course of COVID-19 to instruct social media companies to take down content that the government didn't like. So this is a disappointing decision from my perspective and the perspective of many civil libertarians and progressive free speech defenders that we've had on the show. The decision was 6-3 with Amy Coney Barrett writing the majority opinion, and then the three dissenting justices were, you can probably guess, Alito, Thomas, and Gorsuch as well. So the majority didn't actually decide that the government's actions were permissible. Mm-hmm. They just declared that the plaintiffs did not have standing to bring this case. There's a very complicated, sort of legal situation under which you can bring a case against the federal government. You have to prove that you were harmed, and that there'll be you're under threat of a future harm, and that you're going to get relief actually by what you're asking for. And so there's a multi-part test that the majority said they didn't clear. So they didn't actually rule on whether the free speech claim was valid, just that the case was not legitimate for that reason. The other three justices disagreed. They said the plaintiffs did in fact show that they were harmed as a direct result of the government's action, and they also wrote in this decision that was authored by Clarence Thomas and joined by the two other justices that he thought the free speech violations were pretty vast.
Right. It calls into question if you're a consumer on social media's companies are businesses. And so by being a user on a social media website or platform or app, you are essentially a consumer of a product, and the exchange you're making is, you're viewing advertisements on the website. And so in that sense, the Supreme Court, I believe, is viewing this as these companies are businesses, and so them making decisions about who's a user on the website is their business decision.
Yes, that's an important distinction, because people will say this all the time. Oh, I'm being censored on Facebook. I'm being censored on Twitter. We can use the word censorship in a very colloquial way.
Right.
Maybe I'm being censored if I'm kicked off Reason magazine. I don't work there anymore. Have they censored me? But they're a private employee and they can choose to work with whoever they want. Where the actual literal censorship comes in on the part from a First Amendment standpoint is the government can't order you to be fired from your job because of your views. So did the federal government in effect do that when they were sending all these messages that have been revealed as a part of the Twitter files? I delved into a lot of them for my own Facebook files installment, where I looked at all the emails between the Centers for Disease Control and Facebook, where content moderation was basically wholesale outsourced to the CDC. And the CDC wanted, posts, anything that could in any way contribute to what they termed vaccine hesitancy, they wanted taken down. Obviously, we saw a lot of pressure to take down things related to what the government says is election misinformation, including just joke posts, including, hey, Democrats, remember to vote on November 12th, not November, whatever the day is. Clearly satire, clearly jokes. Mm-hmm. And the federal government wanted that taken down as illegal election misinformation. Of course, the most infamous example of this is the Hunter Biden laptop story, which was suppressed on Facebook and Twitter because, as we've heard from Mark Zuckerberg and others, he'd had conversations with FBI agents where they warned that there was going to be this flood of Russian misinformation coming in. And Zuckerberg and others, feel, I think rightly so, that they got a lot of public blowback from conservatives. They got a lot of complaints that they were silencing conservatives when they're like, well, the federal government was telling us to do this, and very explicitly. I mean, in some of these emails, it's quasi-threatening behavior from the government saying, if you don't do this, you're going to be responsible for the corruption of democracy. And by the way, we're going to go to a legislator and we're going to have you called before Congress to answer for this. And we're going to have a disfavorable profile about you written up in the mainstream media. Like it was really heavy pressure to do this. And so this case was determining whether that pressure would violate the First Amendment. The Fifth Circuit has said that it did, but now the Supreme Court is fundamentally not ruling on that question, so allowing it to be the same way that it was before.
It's a really concerning ruling because the Supreme Court has around 7,000 cases they can pick from a year. They review 100 to 150. So are the 9 justices each reading 7,000 cases or getting briefed on them? No, they have a lot of people who are their interns and their legal clerks. And these are typically people who are fresh out of law school, still in law school. They get this as sort of an internship deal. These are who are making recommendations about what cases are heard before the Supreme Court. That's concerning as a process. I think there's this common misconception that the court only hears cases where there's a clear constitutional violation of some sort or a constitutional question, and they always make it to the Supreme Court and they're always deciding on that, and there's very few of those cases. No, there are thousands of them. And for them to pick this case, to make this precise ruling, when there are so many cases of government censorship and government collusion with social media companies, it almost seems intentional that this court chose to hear this case where they could rule on a technicality and not really make a meaningful ruling about what this means for free speech. And that's really concerning. That's my takeaway from this case and this ruling.
And there are going to be profound, I would argue, negative consequences as a result of this ruling. Because this was being litigated, the federal government had actually decided to stop communicating with social media companies in the interim. They had massively backed off, putting their thumb on the scale and having the kind of interactions with social media companies that so many of us were frustrated about. This is basically a green light to continue that process. At least until a stronger case is brought, which I hope it is. So I have no doubt that more agencies, more comms people this was including comms people at the White House, the FBI, the Department of Homeland Security, the Centers for Disease Control and Prevention. Don't forget that President Biden, in the summer of 2021, got in front of a TV camera and said, Facebook is killing people. He said, they're killing people, with reference to Facebook, because they were not taking down enough COVID misinformation. Then Kate Bedingfield, who was at that time the White House Deputy Communications Director, or something, had some comms role in the White House, she went on TV and said, if they don't do more, they being the social media companies, to take down misinformation, we're going to look at Section 230, which is the federal statute that shields social media companies from some liability, that basically allows them to let you post at will. The reason social media companies, anyone can post on Twitter and Facebook, is because Facebook can't be sued if you say something libelous, something defamatory on social media. If you said something libelous about me, Jessica, I could sue you. You wrote it on Twitter. I couldn't sue Twitter. That's how Section 230 is structured, to make the internet possible. Because obviously, if the companies took on liability, then social media would just not operate this way at all. So the threat to take away this protection was a tremendous, tremendous, powerful threat of adverse regulatory action aimed at the companies, unless they fell in line and did what the federal government wanted. And they did. And then they took down accounts like Alex Berenson, who was a prominent skeptic of vaccines. Martin Kulldorff, who was I believe affiliated with Harvard and was, again, would not describe himself as anti-vaccine, but had some questions about mandates and other COVID mitigation efforts. We've interviewed him on Rising before. That he was suppressed on social media as well. And the case was about whether the federal government pushing them to do that violated the First Amendment, and for now the answer is still no, which I think is really unfortunate.
And it's not like this was a lawsuit with a lack of evidence. It brought to light email communications between Andy Slavitt, the Biden advisor, in March of 2021.
So damning.
So damning. He was emailing with an executive at Facebook, Nick Clegg, who's a former British politician, and he expressed concerns about free speech if he were to take some of these videos down, what you alluded to. Some of them were memes about the COVID vaccine and a video of Tucker Carlson questioning the vaccine's effectiveness, not saying don't take the vaccine and here's why. It's not that it was harmful speech, simply questioning the vaccine.
Right.
And Clegg responded, I'm worried about free speech concerns. This is someone who's a former British politician who's now an executive at Facebook saying, I have free speech concerns around this, but instead what we're going to do to quell your concerns is demote the video so its traction is 50% less.
Yeah.
And so did the government say you have to do this by law? No, but did it influence executives? Certainly. And of course, those executives are worried that they're going to then be regulated or sued by the government if they don't comply, that there's going to be some kind of repercussions if they don't play ball. And so is it an official, legal thing that the government says you have to have this user take this down? No, but there's clear evidence that they coerce the executives to demote videos and remove videos based on their content.
Yeah.
And it wasn't favorable to the Biden administration. That seems to be the motivation there.
And there were also cases, we should mention, where the suppressed speech or the suppressed accounts, the rationale from the federal government was objectively wrong. On the Russian misinformation front, there were cases where the federal government, where FBI agents or federal bureaucrats told Twitter to moderate accounts, saying these accounts are Russian propaganda accounts, or they're fake, they're Russian bot accounts. And Twitter looked into it internally and was like, these are real people. These are Americans. These are not Russian bot accounts. Now you're asking for moderation, asking in special little quotation marks, asking us to take action against American accounts expressing legitimate political opinions on a false basis that these are bots. So anyway, that's the ruling for now. I'm sure we'll continue to discuss it this week and next, perhaps with some of our favorite guests who are also very invested in this ruling. I have no doubt that there will be further legal action brought on this basis, but for now, job owning back on the menu. More Rising right after.